Hello everyone, welcome to the channel Scientellectual. Now we are in the chapter 23. The heading is Miscellaneous. The sections that we are discussing in this video are section 140 and 141. This chapter of Indian Patents Act deals with certain provisions that are not exactly the parts of patent prosecution, but it is important from the point of view of different aspects related to the patent system. Thus, are so collected under this chapter and termed as miscellaneous. Let's have a look at section 140. Avoidance of certain restrictive conditions. Subsection 1. It shall not be lawful to insert in any contract for or in relation to the sale or lease of patented article or any article made by patented process, or license to manufacture or use a patented article, or in a license to work any process protected by a patent, a condition, that is, it is not lawful to insert a condition in contract or license, etc. The condition is like to acquire the purchaser, leasee or licensee, that is, who is purchasing or having lease or having the license, to acquire from the vendor, lessor, licensor or nominees, that is, who are giving the lease, license, etc., or to prohibit him from acquiring or to restrict in any manner or to any extent his right to acquire from any person, or to prohibit him from acquiring except from the vendor, lessor or licensor or nominees any article other than the patented article, or article other than that made by the patented process. That is, no condition can be inserted. If it is inserted, then it will be unlawful. No condition can be inserted like as if purchaser or leasee or licensee needs to take permission from the vendor, licensor or lessor or who is giving nominee of any article which is not at all protected under the subject patent invention. If the vendor, lessor, licensor, etc., those persons are giving extra condition that is not under the patented invention or not related to the patented invention, either may be product patent or process patent, regarding that no condition can be inserted in the contract or license. If it is inserted, it will be unlawful. In similar manner, some other conditions cannot be inserted like b. To prohibit the purchaser, leasee or licensee from using or to restrict in any manner or to any extent the right of the purchaser, leasee or licensee to use an article other than patented article or article other than that made by the patented process which is not supplied by the vendor, lessor, licensor or his nominee. That is, whichever is not supplied by vendor, lessor, licensor, if that article or the article made by the patented process, still the vendor or lessor is giving any conditions on those articles which are not at all under the patented invention, then that condition is unlawful. C. To prohibit the purchaser, leasee or licensee from using or to restrict in any manner or to any extent the right of the purchaser, leasee or licensee to use any process other than the patented process. That is, there should be no condition to restrict or to prohibit the right of the purchaser, leasee or licensee so that he cannot use any process other than the patented process. D. To provide exclusive grant back. Prevention to challenges to validity of patent and coercive package licensing, and any such condition shall be void. Now, what is exclusive grant back? Grant back is considering in the license agreement. A licensor can ensure that when licensing out patents covering its technology, any improvements by the licensee are granted back to the licensor. That is called exclusive grant back. Now, what is coercive package licensing? This is a case where patentee has the patented article and some non-patented products as well, and claims the licensee to take both the products together as a package, and forcefully includes the package in an agreement. As per this section, that condition is unlawful and thus void, as any products not protected by patent should be free to use by public. As an example, we can say, suppose a person get a patent for his invention of a book binding machine that is capable of binding any books having say 50 to 500 pages. Now, that person wants to sell or license his patent on this machine along with the pages, saying that these pages should be used for the books only. But this is not at all protected by the patented invention, so he cannot force to take that pages to a person who is having the license. So, coercive package license is not a good practice, and paying royalty for such license is extra burden on the licensee. Section 140, subsection 2. A condition of the nature as mentioned in clause A, B or C in subsection 1 shall not cease to be a condition falling with that subsection merely by reason of the fact that the agreement containing it has been entered into separately, whether before or after the contract relating to the sale, lease, license of the patented article or process. Subsection 3. In proceedings against any person for the infringement of a patent, regarding the infringement proceedings, it shall be a defense to prove that at the time of the infringement there was in force a contract relating to the patent and containing a condition declared unlawful by this section. That is, someone can make it a defense as if whatever the licensor or leaser has given in condition, it was in force and unlawful, provided that this subsection shall not apply if the plaintiff is not a party to the contract and proves to the satisfaction of the court that restrictive condition was inserted in the contract without his knowledge and consent. Section 140, subsection 4. Nothing in this section shall affect a condition in a contract by which a person is prohibited from selling goods other than those of a particular person. That is, nothing can affect a condition, that is, no condition can be in a contract for which a person can be restricted or prohibited from selling a good other than a particular person. Nothing shall affect or nothing shall validate a contract which, but for this section, would be invalid. And C. Nothing shall affect a condition in a contract for a lease or license of a use of patented article by which the lessor or licensor reserves to himself or his nominee the right to supply new parts of patented article as may be required, or to put or keep it in repair. That is, there should be no condition in a contract where the lessee or licensee is forced to take any new parts of the patented article from the licensor or lessor, which needs to be kept during repair of any article or patented article. Section 141. Determination of certain contracts. Subsection 1. Any contract for sale or lease of a patented article or license to manufacture or use or work a patented article or process, or relating to such sale, lease or license, any time after the patent or patents by which the article or process was protected at the time of making the contract has been ceased to be in force. That is, every patent has 20 years of time. Now that time period is over. After that time period, it can be determined by the purchaser, lessee or licensee of the patent about the contract of the patent on giving 3 months notice in writing to the other party. So after being seized any patent, the contract can be cancelled or revoked, and that can be determined by the purchaser or lessee or licensee, and he will give a 3 months notice to the other party. Subsection 2. The provisions of this section shall be without prejudice to any right of determining a contract exercisable apart from this section. Thank you all the viewers for watching the video. These sections are very important under Indian Patents Act 1970, and in our all videos we are giving all the necessary informations regarding Indian Patents Act 1970, and we believe that will be very helpful during the preparation of Indian Patent Agent exam. Thank you.